Good morning, everybody. Welcome to the Retired Living Truth series, and today's topic, the truth about getting your legal affairs in order. My name's Brett Janelle. I'm your host and moderator today, and my co-host,
Annette Janelle,
my wife and business partner. And we just want to say thank you so much for all being here. We have two amazing panelists today who are going to help us regarding what we should know about our legal affairs. I'm just curious first, who believes they have everything already in order by a show of hands? Come on, more hands. I want to ask the same question again at the end of the day after you've heard our panelists and see if you still think you have all of your legal affairs in order. So we typically do some variation of this topic each year. Who has been to a panel where we've had some attorneys on before? Good number of you. Yeah, so we repeat this each year for good reason. And that is because in our real estate business, we come across people who didn't have their legal affairs in order, and it causes us all sorts of problems, doesn't it, Annette?
It certainly does. In fact, I was just speaking with a lady yesterday that called me up and saying that she was interested in selling her brother-in-law's home, and he had everything in order. The attorney had said it was all good to go, and she just needed to wait 90 days, but then she let me know how title was taken, and I'm like, you're going to have to wait. So you don't want, she's in a position where she now has to carry this house, and financially it can be a burden. So you don't want to do that to your loved ones. We also had an attorney from California. He said, I did my own will. Not his own will. He did the will for his brother. Everything was in order. He wanted us to sell the house. And I said, it's a will. Do you have a trust? No. Well, this is a probate state. You're going to have to go through probate. He said, well, I did the will myself. I shouldn't have to do that. I'm like, but you're a California lawyer, so we do things differently here. It is very helpful if you have something done in another state to know how it's done here in Nevada and make sure that everything is in order. So you don't have that happen to you and have to go through probate.
So how often do we have clients in our real estate business where things don't go smooth? It's pretty often, isn't it?
It is quite often, yes.
Even though people say, yeah, we've got everything in place, usually something's being missed. So with that said, I think we'd like to have our panelists.
No, hold on one second. If you have got a cell phone, please put it on silence. Sometimes we forget we do have a screen saying to silence your cell phones, but every month we seem to have a few characters that decide not to do that. So
no, I actually didn't mention it before we started as well, so thank you for bringing that back in.
Great.
Thank you. So Rich and Lou, if you could come and join me up here, please. So does everyone have a handout? You should all have received a handout. Can I just ask, if you come up with questions for our panelists as we go along, please write them down on the front page. And somewhere around about 11 o'clock, we'll open it up for your questions, and you can ask as many questions of the panelists as you like. And I would just ask you, when we do Q&A, questions and answers, if you can just keep it to questions rather than comments and so forth, because I'm sure there'll be lots of questions today, if you wouldn't mind. So I've prepared questions I'm going to ask on your behalf of our panelists. We'll do that for roughly about 50 minutes, 55 minutes. And then we'll have some announcements, and then we'll open it up to your questions, and we'll finish here at 11:30. So maybe if I can start with you, Lou. Would you mind introducing yourself and why you might be here today with us?
So I'm Lou Robinson, President and CEO of Alliance Trust Company. I've been doing this since 2010, and Nevada's a great place for to have a trust. So
Fantastic.
The #1 state in the nation, actually.
Awesome. We'll find out more about that. So thank you, Lou, and thank you for being here. Rich.
So Rich Schultz, I'm an elder law estate planning attorney. The way I use that is estate planning is handling all the stuff that happens after somebody stops breathing, so trusts and wills and probate and all that. And my client came to me, heard this. I had a client about 20 years ago come up with this one. Elder law is what happens when you don't stop breathing on time. So it's that kind of stuff. So I've been doing that close to 30 years.
Thank you, Rich. As you probably know, Lou, you're going to have some competition with your jokes today. Yeah. So maybe if I could start with you, Lou. What are some of the common misconceptions people have regarding the need to have trusts and wills in place, especially when it comes to blended families or complicated relationships? What are some of the things that you come across in terms of people's misconceptions?
Well, I think that the first misconception is that I think everybody thinks that they can control everything from the grave, and that doesn't happen. That'll create a tremendous amount of resentment. And then also, as far as blended families go, you know, maybe people who have blended families are already aware, but I think some people are really fooling themselves and thinking that, oh yeah, everybody gets along great, it'll be no problem about God. And about more than 90% of the time, it's World War III.
And do you encounter cases where perhaps there's no blended family now, and we have a trust and everything in place, but things change over time? And
yeah, actually, that's a great point, which is, you know, I mean, couples, one of you is going to outlive the other. And, you know, after a while, people need companionship. And that can really change all the planning that was done years earlier. And there's a lot of unintended consequences there that maybe you don't think about at the time you set up the original estate plan.
thank you. Rich, what would you like to add to that in terms of misconceptions people have about estate planning?
You know, I think that the first one is I don't need any because I just have 2 kids and everything's going to be split equally. And that said brilliantly, even if that's true, you still may end up going through probate and getting the court involved and waiting, 14, 15 months before anybody gets anything. I think in furtherance of the blended family, there is even if they all get along, and you've been married for a long time, there's still this sense for a lot of families that, well, this was my dad's and that was your mom's. And you want to be clear about what's what and who's who. And the other one that we run into, we mentioned yesterday, is that at the first death, particularly if it's a second marriage or third marriage, you've got the kids of the spouse I'll call it the new spouse that dies, sometimes show up and say, I want mom's stuff now, or I want dad's stuff now. And that's not what you want to have happen. Maybe it is, but you better spell it out. Because that can be a lot of tension, a lot of arguments.
Thank you. So Lou, can you give some examples where maybe poorly structured legal planning has led to unintended consequences, disputes, things that you've seen in your practice administrating trusts?
Yeah, I think surprisingly where all the fights occur is related to personal property, which oftentimes has very little financial value, but can have extreme sentimental value for everybody. So in my family, my grandfather was married many times, had a blended family. He was a great lover. He was an attorney and a great lover of chess. And so he thought it would be a fantastic idea if all of his children played chess matches to determine who got what related to the personal property. You can imagine that was a complete disaster. And to this day, I think there's still a lot of animosity over who ended up with the handmade poker chips or the handmade imported chess set. And, it was really, that is an extremely bad idea to just pit your children against each other right out of the gate. So that definitely has some unintended consequences.
Thank you. So how are you with chess?
Actually, I rarely play anymore. It's a kind of a tense subject around the house. So.
I can imagine. Rich, got some examples for us?
I do. So the first thing I would say is that most of what you own is useless and nobody wants it. But I do almost guarantee that there's 5, maybe 10 things that matter. And you want to know what those are. They may not be what you think are important, but the kids might. So the story I've got, the biggest fight I had up until recently was many years ago, and it was over a woodworking set. So Granddad had a woodworking set, very nice, steel, the old steel, oak handles, but rusted up and, kind of cracking and that kind of stuff. And the son and dad had done that. So son now had a grandson, and they were doing woodworking and wanted to get Granddad's woodworking tools to work with his grandson and start to keep the family thing going. Well, the daughter, who was in charge of everything, gave it away. And that fight was so bad, the judge actually pulled the lawyers into the office. It was in the middle of the hearing and said, if you guys don't resolve this, I'm throwing you both in jail. Because they were so angry. So there may be little things that you don't think about.
So that's thinking about the distribution of things that are important in both of those examples. Lou, do you have another example perhaps where it comes down to more poorly structured or omitted things in the trust documents?
Yeah, so oftentimes, just as you accumulate things over your life or dispose of things over your life, throughout your life, there can be some unintended consequences. So this is actually part of my family. So my wife's mother wanted to have one child have a house, and then the two children would split the financial assets. Well, the issue was when she passed, the only thing that was left was the house. There was about $200 in financial assets, and that really has created some animosity in that instance, just simply because it was an unintended consequence. And even though she meant well when she did it, the one thing she didn't want to do was create the tension that she did. So that when you're setting everything up initially, you have to kind of think through what it's going to look like at the end. And it could have been easily in reverse, right? Maybe she had to sell the home, and now the trust document is unequal the other way, or there's a number of different ways that could go. So just be mindful of that. I will say percentages are often the best way to go, in my opinion, rather than specifically less.
So that might be a good reason to have someone who knows what they're doing helping you versus
Exactly.
trying to do it yourself, whatever the case.
Yeah, I mean, some attorneys won't necessarily put any thought into how you're going to structure this or bring up these points. I do think it's important that you, rather than just having a cookie cutter document, that you do think about these issues.
Excellent. Rich, do you have another example? And actually, before you answer, are we good on microphones and everything? I noticed Kim, you are. All of us speak a little louder. Thank you.
Bring it a little louder. Is this better? Yeah, good. I think I kind of reiterating what Lou said, but I'm going to say it from the client perspective, where if somebody comes in and they say, I want the house to go to Johnny, I want Mary to get the RV, and I want, Bobby to get the cash or whatever. And then I say, okay, but, in the client's mind, that's very simple, right? This is going to be all equal and it's going to be great. But then you run into what Lou just pointed out. What happens if you have to sell your home? What happens if you give up the RV because you don't want to travel anymore? And so a lot of times, you talk to people like, oh, that's getting too complex, I don't want to deal with it. But the complexity sometimes makes it simple later on. And so when you do specific gifts, when you do something like that, you really do want to think about, an if-then kind of scenario. And then the other one that I'll say that we've had great battles over, Lou brought up the antique chess set, where people do specific gifts in the trust and say, I'm going to give my grandfather clock to so-and-so, and then they downsize, the grandfather clock isn't around anymore. Do they have the right to go get it from whoever has it? They think they do. So, yeah.
Wow. I hadn't thought of that one. So the grandfather clock could have gone to my sister, put in the documents, it's meant for me, and now I'm telling my sister, well, Dad really wanted me to have it.
Wow. Yes.
Yeah, not good.
And actually, in my family, I love my brother. I think he's a great human being, but he has a tendency to just bogart those things, right? So that's laying around. Oh yeah, now I've got it. So the only time it's ever really made me mad was when he took the Cincinnati Enquirer I had, which is where I grew up, when Pete Rose broke Ty Cobb's all-time hits record. And he decided that was his. But, this stuff is really, being in this business, I don't care about that kind of stuff because I'm used to it, but most people do. And so I will just say that if you have a sibling that's, or a child that's laying around, they may just take it for themselves. That usually happens. And then that's where the fight us. So,
Thank you. So let's change gears a little bit. Who's familiar with the power of attorney? Most of us know what a power of attorney is. Many of us. Could you start, Rich, by just explaining what is a power of attorney? Is there more than one form? And why is it so important that we all, everyone, have one, especially as we're all aging?
Okay, so a power of attorney is just a document where you name someone to act on your behalf. And it can be right now, it can be if you want to become incompetent. And there's really three kinds: of general, a limited, and a healthcare. Healthcare power of attorney is what it sounds like, where you nominate someone to make healthcare decisions for you when you're unable to. And you can leave directions in there that are detailed or very broad, or so they know what decisions you want made when. Super important. A limited power of attorney is a power of attorney where you give someone limited authority to do something. So a lot of times when you refinance a house, you buy a house, you sign a limited power of attorney for the title company to correct what are called scrivener's errors, typos. So it's not a general, but they can correct your name if it's misspelled or if the address is wrong or something like that. A general power of attorney, you're going to love this one, this is a lawyer term, is anything that's not a limited power of attorney. I love being a lawyer. And what that really means is it's you giving someone the authority to generally deal with your financial affairs. And that could be anything from magazine subscriptions, credit cards, taxes, registering your car, choosing health insurance, up to buying and selling a house and investing in your IRA and taking money out. They are vital documents that they're both done properly, that you've got in place. Because if your life goes the way we all fear, right, I don't die on time, remember that elder law thing, right? If you don't have a good power of attorney in place, both for healthcare and finances, you most likely will end up in something called a guardianship. And in that case, the court says what happens, not you, not your wife, not your kids. And it's worse than that because the court will appoint a lawyer for you who's never met you while you were sane and never knows what you want. They're listening to you while you're not quite there, and you can't understand what they're trying to do, and you end up spending a lot of money that could be avoided, right? What's the best part about two lawyers? They both get rich.
So if I don't have one, can't I just wait till something happens and then put it in place? I just don't really want to deal with it now, Rich.
Yeah, no, you can. To do a power of attorney, you have to be legally competent to sign the document and understand what you're doing. And I have clients, probably most of the guardianships I've got right now, or we have right now, are cases where the person maybe a year ago, 2 years ago, could have done a power of attorney, and now they can't. Why? Because they don't even know who they are. But sometimes they just need to be able to understand what they're signing. And if you wait too long, again, we're back in court. That is definitely something better. That's better to do well before you need it than when you think you need it.
And you said that sounds like an extreme case when they don't know who they are, but is it even earlier than that, potentially, rather than being competent?
It can be much earlier than that. There's this, there's a series of questions you run through when somebody drafts a power of attorney for you. They say, do you want to do this, that, or the other thing? And you need to be able to answer each of those questions clearly and understand what's being asked. Some of those questions, some of you in this room, it would take me maybe 5 minutes to make sure you understood it. And you all got here on your own, you're living on your own, you're doing great. Now imagine, you look at your neighbor, not in here, you're imaginary, and they're doing great. They know their kids, they know who they are, but they have a really hard time doing math. Or maybe they forgot what their favorite TV show is now, and you have to go and show them how to operate the remote control. In that situation, you probably can't do a power of attorney.
So now we're looking at guardianship.
Now you're looking at a guardianship to deal with everything, including getting at your IRA to pull money out to pay for your care. You may think that my wife could just go pull the money out for me if I need it. Not the way it works. If it's my IRA, my wife can't get at it without my permission. That's a big issue.
So what are some of the things that might happen to us? We're all competent today, but for tomorrow, for us not to be competent. What are the things that happen in people's lives that cause that all of a sudden?
some version of traumatic brain injury, whether it's a stroke or a slip and fall and you hit your head. A lot of times people at home, they don't do the safety work at their home. They get out of their bathtub, slip, and they break their hip, but nobody ever talks about the bang on the back of the head. That's probably the most sort of traumatic version, the quick version. The other one that happens is with dementia, or of any type, right? Dementia has so many different types today. We think of it as a slow slide, right? That it starts here and I just slowly go down, and this is the way it works. It's actually stair steps, in my experience. And you may be doing okay, but then maybe one day you don't drink enough water, or you get a cold or something, or your brain just wears out and you take a big drop. And literally within the span of a week, you could be able to sign a power of attorney and then not. My again, kind of the punchline of this whole thing is, if you should have a power of attorney, even if it's one that only comes into effect when you can't take care of yourself, so that you've named someone to make those decisions for you. If you don't have somebody in your family that you trust, or maybe lots of folks, just don't have anybody, that's what Alliance Trust Company is for. They can do that for you, but it's really important.
Thank you. And for those who aren't in a financial position, if we have friends, neighbours, and so forth, there are resources in the community to help people put these things in place.
Absolutely, yeah.
So no reason not to have them. So Lou, let me jump to you. So in terms of estate planning documents that we might have put in place 20 years ago, we haven't really looked at, what might have changed from our younger years to now that we should really be thinking about, or people overlook in terms of updating their documents?
Yeah, so I think assets is number one. Do you still own the assets that were originally contemplated? What is the size of your estate today in comparison? Have you added assets? Have you added kids? Hopefully nobody in their 70s is adding children, but it's not unheard of. So, but that is, actually you could add children. They just might not be your own, right? Maybe they're your new spouse. So what most people don't realize is in a most revocable living trust, which is, I think, the vast majority of what people have, you both spouses are trustees while they're alive and competent. But if one passes, now you just have one spouse that's in charge of everything. And if that spouse remarries or the surviving spouse decides to change things in the trust document to include maybe a companion's children or whatever, there are ways to address that Rich usually discusses with clients. But that, that's a big change. And the children, your own biological children, in the cases where that happens, that's where the conflict arose.
So that could equally also be the loss of a child. There seems in the trust for that child.
Yes, the loss of a child, or even more importantly, what happens if one of your children has an accident and is no longer able to take care of themselves. And so your original plan was to split all the assets equally, but now you have a child who's going to need vastly more financial support in their life because they're not able to care for themselves. That happens more often than you think. And so that's really making sure that your plan addresses that instance, I think is really important. Because if you're just going to split things three ways and you have a normal size estate not subject to estate tax, I have to say that for a special needs child, that's not going to be enough.
Thank you. Rich, what would you like to add?
I think there's one thing is law changes over the last 20 years. There's been a ton. The estate tax has changed dramatically, so somebody may come in with a trust that's designed to protect the estate from estate taxes that's not relevant anymore. Makes things more difficult than they need to be. Maybe remarriages, new kids. I think Lou said that very well. The other one that I see is just the wrong decision makers in place a lot. where they've got, maybe 10, 15 years ago, it made sense to have the eldest child as the decision maker, but then maybe they've made poor decisions in their life. Or maybe the youngest child is now a nurse or a doctor or an accountant or something. They might be a right decision maker for a certain role. We see that a lot. But really probably the biggest one is the document's just out of date in general. They don't match your life. They don't match the new law. They don't do what you think they do. So it's worth getting them looked at periodically just to make sure what you have, if you have something, is up to date and working correctly.
Does that include our healthcare directive? Has that changed from what we signed 10, 15 years ago to perhaps now?
Yeah.
10 years from now?
Absolutely. So I always tell people, I wake up and I've got those early morning aches and pains. So I always lay in bed and I move my ankles and calves a little bit just to make sure everything's working down there because I've had some injuries. Right now, that's a little bit miserable. When I'm 90, it's going to be, I'm tired of this. And if my heart stops beating, let me go because I don't want to move my ankles anymore. That's dramatic, right? But it is true. If you're in your 50s, it's like, hey, swing for the fence, do everything you can. Maybe even into your 60s. Maybe into your 70s nowadays, right? I always tell people 70s, then you're 60, or actually you're 50. But maybe you've gotten older and it's like, I don't want any life support. If it's where I'm not going to have a quality of life, or maybe I've got a diagnosis I don't want to think too much about, and I have a heart attack, maybe I want to put in a medical instruction that I don't get any care. Those change a lot, and they change just over the course of your life, right?
And I would just add, in my opinion, the medical power of attorney, medical directives are the most important. If you have multiple, like oftentimes parents will say, okay, all three of you have equal power to make decisions. Honestly, that's really not a good idea because all three of your children probably don't think alike. And then you're frozen without being able to make a decision. And it's the same in your trust as well. It's not a good idea to have all three decision makers in any fight or four, whatever. Any fight just brings everything to a halt.
So any examples of that with the healthcare directive? I can see that potentially causing a lot of pain and dispute between siblings who are trying to make a decision about mum or dad end of life.
It happened with my mom, actually. So she had nothing in place, so it was the three of us to decide. And my brother and sister were really having a hard time with that decision. My mom was very practical and just said, look, when I'm not there anymore, then that's it, I'm done. And she hated doctors, hated needles, couldn't stand any of that. And she was hooked up to a bunch of machines, and my siblings just weren't willing to let her go. And so it took a while. It was difficult. So, and created some animosity amongst us as well. So,
thank you for sharing that. So you're suggesting having someone who's nominated who's going to make the decision. Do they need to know about that they're the person?
Yes, absolutely needs to know. That's the other thing, yeah, because a lot of times we'll do these documents and then people don't communicate them to their children, and nobody has. And then, well, if you don't have a copy of the document, you don't know, and you're in the hospital because of an accident and a coma. Nobody knows who's supposed to make the decision. Nobody knows where the document is. So it's really important to communicate that to whoever you do nominate.
Anything else you want to expand on, though, in terms of communication? What else should we be communicating with our loved ones?
Well, I honestly believe in open communication where the trust is concerned as well. There are reasons, and I'm sure there's somebody in here that has a child that they don't want to give anything to. But, which you're allowed to do in Nevada, but you should still communicate to those that aren't a thorn in your side. You do need to communicate with them at least somewhat. Where to go if something happens, where your documents are located, or, are they with an attorney, are they with a trusted friend, whatever. That is important. to communicate those issues, because at the end of the day, this really is pieces of paper that we're supposed to keep track of. So,
and do those pieces of paper always make sense to the person? If I wasn't told I'm the one making the decisions and I am now reading what it is that mom or dad wanted.
Right, and that will also create some conflicts. Well, why did you pick Billy and not me? Or, you know, and to be honest, if you do choose one of your children to be trustee or executor of your estate, just know you're putting a tremendous burden on them. So if they're an attorney, and like Rich, they do this all the time, yeah, it's a piece of cake. If they're a doctor, maybe they're an airline pilot or travel, I mean, it's really a lot of work. And they're going to have to use up all their vacation time for sure to handle these issues.
So if I'm choosing one of my children to be, you know, the person responsible, the trustee, or my healthcare directive, I should let them know. Do I let them know why it's them and not my other two children? Do I tell my other two children that it's, you know, child number one, the oldest child, the youngest, whatever? Any suggestions, thoughts that would help the audience?
If you do name one of your children, I would communicate it to that one, maybe not necessarily the others, but you should probably give your logic or reasoning why. If you're naming them as trustee, then probably it's because they did something really bad to make you angry, because you just put a huge burn on the, like they burned down the house, or were responsible for losing the family pet. So,
Rich, what would you like to add? Thank you.
I just had a vision. I blew up my fireplace when I was a kid.
Would you like a little closer there, Rich?
Oh, I blew up the fireplace in our house when I was a kid, so I think that's why my mom put me in charge. Thanks for that. You know, I think I would reiterate what Lou says. On the healthcare side particularly, though, if you name a child to make decisions for you, and you should, you know, let them know. And let them know what you decided and why. You know, I at least try to do a pretty good job putting your rationale and everything in writing. But there's nothing like it coming from you know, and saying, hey, you know what, guys, I've had a great life, let me off the off-ramp. Or, hey, you know what, I want to see my 32nd grandchild, keep me around till they're born. You know, whatever that is, I think that's super important. I'm a little, like Lou, reluctant about sharing documents with people. I think you want to let a child know that they're the trustee, maybe. Or maybe let the children know that you've done your estate planning and this is where the documents are. Why I don't like to share documents, other than maybe the healthcare power of attorney, is that if you change them, you have to do two things. One, you have to go get the old one. And two, you've got to tell everybody that you changed it. So maybe you've decided you have a favorite daughter-in-law, and you want to give her something specifically. Well, now you've got to let everybody know while you're still breathing that you love your middle son's daughter-in-law and you don't like the other two spouses. I don't want to do that.
Awkward.
Yeah. And generally it's just keeping track of documents if you start distributing too far and wide.
To that, I would just say, really, it's the attorney is where your documents should reside. And you just have their business card. Maybe Rich can give you an 8x10 picture of himself, and you can put it on your fridge so your children know where to go. But
we just can't use the one that comes up on the slide anymore.
I need to update that. So anything else on communication, Rich, before we move on to the next question?
No, I think the big one, if I were to talk about, if you are doing things uneven distributions, let the person that you put in charge know why you're doing it, so they can kind of lean back on something when they get the noise, you know, people making noise at them. They can know, no, I know nobody's happy with me now, but I'm doing what my mom and my dad wanted me to do. It's helpful in that situation. If you think there's going to be a fight, there's a guy here you should talk to, because they're very good at following your instructions and not being swayed by family pressure. You know, I just coming back to the healthcare as I sit here today, just because I'm dealing with that with a couple of clients, is you really do want to let people know who your healthcare decision maker is and what decisions you want made. It's really, you know, it's so hard. Like Lou's family, I'm making this up, but I'm sure this is what happened. 3 kids there, and the doctor comes out and says, hey, there's your mom. She's at 98.6. Yeah, she's all right. Do you want me to kill her? I mean, that's what they hear. Now, if you're the one on the table and we were to talk about it right now, it's like, heck yeah, only probably won't use heck. And you have no hesitation. Well, let your kids know that too. So it's really important.
And I just want to add that, documents are great, and it gives a specific set of instructions. And a company like mine, we're used to following those instructions and understanding what they mean, because it really is a whole different language. But what's lost in those documents is the intent of the grantor or the signer of the documents. And so that's what gets lost in translation. And children will really appreciate, a little bit of that intent. Even with gifting specific assets, I tell people this all the time, do it while you're alive so you can see the level of appreciation. Maybe there's a story that goes with that asset that you want to pass on to the next generation. In my family, it's my grandfather's watch, which I'm not wearing today because I broke the band, which is probably the reason it took so long for my dad to get it to me to begin with. But now I have to fix it. But he gave me a great, 30-minute story about the history of the watch and why it was important in the family. And, that I really appreciated.
Yeah, it means a lot, doesn't it?
Yeah, it means a lot. It makes that item so much more important to me. I hold that, and it was important to my dad, so it's great.
Right, without that story.
Without the story, it's just a watch. Yeah.
So let's talk a little bit about differences between states. What does the audience need to know when it comes to their estate planning, inheritance, about differences between different states if we perhaps have things in different places? You'd like to take that? You want to start with that, Rich?
I'll start with it, and Luke can fill in the blanks. So legally, I'm going to say technically, documents are supposed to go state to state. So if you've got a power of attorney that's legal in New Hampshire, it's supposed to be legal in Nevada or Arizona or wherever. Supposed to be and actually is are different things. And we routinely have banks, financial companies, refuse to accept out-of-state powers of attorney. So if you move from state to state, you definitely want to get those updated and revised. Trusts are much the same way. We do, I don't know how many of you, well, I won't make you do that, but lots of people from California. One of the cool things about California, aside from the weather and the geography and all of that, and sometimes really good food, is it has laws, and lots of laws. So your trust is built to either skirt around or incorporate or do that kind of stuff with California law. And maybe you move to Nevada and you don't need all that confusion in there. Maybe we can simplify it down. Maybe we got to be a little bit more clear because Nevada doesn't have that law. So it's important to make sure that matches. And then the time bomb that's happened to a couple of my clients nowadays, everybody's afraid of the federal inheritance tax, right? Oh my gosh. But the exemption is $13 million. How many of you have $13 million? Yeah. Don't raise your hand, we can help you. But how many of you have $1 million? It's not very much money anymore. I mean, it's a lot of money, but it's not. Well, if you're in Oregon and you have more than $1 million of property, you're going to pay an estate tax to Oregon. So if you've got a client that had a house on Cannon Beach that we were lucky because he got an appraisal at $998,000, MIA appraisal, made as instructed. But it was really tough. They almost owed an estate tax to Oregon and didn't owe tax anywhere. I have a client who left everything to charity except a series of specific gifts. Lots of their properties were in Hawaii. Guess what? They don't owe a federal tax because it all goes to charity, but the specific gifts are greater than the Hawaii exclusion. They owe a 30% tax to the state of Hawaii. So there's a reason if you own property in different states to talk to lawyers. The other thing about it, we talked a little bit about this. If you own real estate in 2 states, you want a trust, period. You will run a probate in 2 states if you have property in 2 states, which is twice as good for lawyers and twice as bad for everybody else. And then finally, Lou brought this up yesterday.
Well, I mean, you understand the issue even better than I do, but forced heirship is an issue. So Louisiana is really built kind of on French law and less on English law. And so they have a forced heirship statute, which means you can't disinherit children in Louisiana. And so maybe some of you move to Louisiana later in life, don't even know that. Maybe there's a child you don't want to have something. So it definitely has some unintended consequences. Louisiana law is honestly not a lot of people in other states understand because it is so unique. But the forced heirship just being one of them. The other one is, what if your trustee, you name one of your children, they're in California? People don't know this, but you may be in Nevada, all your assets may be in Nevada, your trustee is now in California because you've passed. You're now subject to, your trust is now subject to California income tax. So the state of California has a 3-pronged test.
Just gonna go back, say that one more time. Everything I have is here, my trust is here, but I've got a kid in California.
Who's now the trustee.
Yeah.
So now all the income of that trust is subject to California income tax.
Wow.
So people don't realize that, but California has a 3-pronged test for taxation. Location of the assets, location of the trustee, and location of the beneficiaries. Any one of those 3 things will make your trust potentially subject to California income tax if you don't address it on the front end. So California is probably the most aggressive tax authority in the world. I mean, they're really aggressive.
Wow. So just going back to that Louisiana one, so if I've got a trust here and I exclude one of my children because they've been terrible, and then I move to Louisiana and pass away, what was the...
Well, I don't know exactly what will happen. I know you can't. Potential is, well, I can tell you one thing that's going to happen. There's going to be a lot of legal fees.
Yeah.
That's for sure. What the eventual outcome is, I don't know. Except for a lot of attorneys are going to get paid.
Yeah. So if I move to another state, Louisiana or wherever, I should be seeing someone there with expertise to make sure that everything's still valid.
Any state, yeah, because that does make a difference.
What I would add, or if you're coming from that state, right, you may have a trust that's designed to remove like a forced spousal share, right, where a spouse is allowed to accept or must be given a certain amount of property. So your trust is drafted a specific way so your plan works the way you want it to. Then you move to Nevada, and that language just blows up under Nevada law. And so that's super technical. I mean, but the point is that there are differences state to state, and you do want to make sure that what you've got that works in Louisiana or Hawaii or New Hampshire, New York's another state that's got all kinds of weird laws. Yeah, New York's probably the worst, to be honest.
We've been waiting 18 months for a probate to open in New York.
That's open, not end.
Yeah, just to get open. The courts are so backed up. 18 months. But I will say one other really important thing. Nevada law is really great for trusts and asset protection. So one of the things is, I'm sure you don't have to raise your hand in case your spouse doesn't know, but maybe you really dislike one of your children's wives or husbands. I'm sure it's in every family. And maybe your child married what you consider to be a monster, and you're worried about their inheritance going to that person. In Nevada, that doesn't happen. If you're worried about that happening, you can always keep it in trust. Nevada is one of the only states in the U.S., and we are the only state with case law to support it, that does not allow divorcing spouses to access the trust for either alimony or child support. And that's very unique to Nevada. There's a few other states that have the same, but none of them have case law that's happened. So I'm not talking about who you're here with today. That doesn't work. I'm talking about for your children. That's really important if you're concerned about who they marry.
What about who they might marry?
Yeah, or even who they might marry. In my case, my children are 18 and 15, and while I worry about who my son may marry, I worry about who may make the mistake of marrying my daughter. So she's going to be somebody else's problem.
So would that be a time to maybe want to relook at our trusts when a child does get married or divorced or there's some change? Like, am I catering to that? Have I thought far enough ahead?
Yeah, not just that though. I mean, I think if you build it on the front end to make it so that the spouse can't access your child's funds, just build that on the front end. Rich, do that easy.
Yeah, and we can definitely build it on the front end. The other thing is sometimes when the divorce happens, your child did not have a good divorce attorney, and their decree, the divorce decree, grants rights prospectively. It grants rights in an inheritance that isn't there yet, and we may need to draft around that, or go, ask the lawyer to amend the decree. But I've seen that happen now twice, so it's a big deal.
Thank you for sharing that. So how often should we be reviewing our estate planning documents, our healthcare directive? What advice would either of you give to the audience?
Well, we were talking about this the other day, and I mean, it's different for everybody, and obviously it's not the most fun thing to do. But I would say, in my opinion, when you're doing your taxes, it's a perfect time to really just put 20 or 30 minutes of thought. Like, are these documents still appropriate for what we have? Because when you're doing your taxes, you're basically taking the inventory of your assets, right? Or Uncle Sam's taking inventory of your assets. You're just I think that's the time. At least 20 or 30 minutes to think about it, but certainly every 5 years you need to have a pretty deep dive if anything's changed. I mean, Rich, and age is also important, right? How old you are will depend on make the decision for how often you need to be reviewing.
Thank you, Luke. Rich?
Yeah, I would say, I think once a year, at least thinking about it. I don't think you need to come in and change anything, although I would love to take your money and do that. No, not really. You don't need to change it every year, but every 3 to 5 years, you definitely want to make sure you've got the right decision makers in place. Like, do I still have the right people? Have my assets changed? At the beginning we said, we're giving, one person the house and another person cash. Do you still own that house? Does it make sense to give them that house? To look at things like that. The healthcare power of attorney, right? I can, looking around the room, I guarantee that some of you have ones that say, yeah, keep me going. And some of you probably still have ones that say, keep me going, and you're ready to get off the get off of the off ramp. Maybe definitely worth looking at. I think every 3 to 5 years is my number.
So when you said looking at our trust documents each year, 20 minutes or thereabouts, so Rich is my attorney. I have a big, huge binder you gave me. You're not suggesting I read that every year at tax time. It's more of thinking about what has changed that might impact something in that binder.
How well are you sleeping?
Pretty good.
Okay.
I was confident when we did it.
Yeah. If you have insomnia, read the whole thing every year. If you don't, don't read it every year. But do take a look. Like, who are my trustees? Oh, right. Yeah, I really liked Mary a few years ago, but Mary married that bonehead. We gotta get. We don't want that bonehead anywhere near my stuff.
Or maybe marry some platinum player at the casino, $50,000 a year. So maybe that's not such a good choice for trustee.
Yeah, exactly. She's now become a high roller.
Because trustees have the absolute authority to do whatever they want with your assets, and nobody's going to stop them. And by the time you get to court to try and recover, forget it. You're not ever gonna. It's never gonna happen. And rarely are they even held accountable. So I will just tell you, having been in probate court a bunch of times, I would listen to the probate commissioner say, "Now that's not your money, right? You have to give that back." And then, I don't have any money here. Oh, okay. You know, I mean, that was it.
Cool.
Yeah, I would say, that the pitfall, everybody, the joys of living trust. One reason why you do want to review it is a trust can be very fast, and your family's in charge of it. The decision maker you choose is in charge of everything very quickly. And if they're the wrong person, everything can disappear before anybody knows it happened. And once it's gone, it's gone. You know that gold coin collection you've been saving in case the economy blew up that's in the safe? If you've got a surprisingly large number of people have gold and silver in their safes at home, which is, I'm a little bit surprised. That can disappear and nobody knows it's gone. And the trustees suddenly driving a Ferrari.
So you're both saying the trustee might have been a good decision at the time, but their circumstances have changed financially, financially, whatever it might be, may no longer be the best choice.
May no longer be the best choice. May have grown up, maybe life isn't going the way they wanted to go. They lost their job. They lost their house when they lost their job, and they just got to get back up on their feet. And that, the extra month cash you have sitting around in that savings account, that's a great down payment. Nobody will know. It's my money. I'm in charge. And they do it. As Lou said, it happens.
And the trustee's spouse often gets involved when they shouldn't. That we see that happen a lot, but where the spouse tries to make decisions for the child you named as the trustee, you can imagine how that goes.
Yeah, what I always tell people, you got him for 18 years. Your spouse has had him every year for 20 years, 8 hours a night, and they'll win. And, the spouse harping in their ears saying, honey, you're working so much harder than they are. You've done everything for your mom and dad. You deserve more. Well, you know what? You hear that every night for a month. And it's hard work. Suddenly believe it, and, maybe they do something they wouldn't otherwise do. So you do want to look at their spouses, too, when you nominate somebody to make decisions.
Or just nominate a professional, honestly.
So I was going to ask you to talk about. So if the trustee is no longer appropriate, I don't have anyone else, just explain how your organisation fits into that whole thing.
Yeah, so we're regulated by the Nevada Financial Institutions Division. It's the same agency that regulates banks within the state. They come in. We have to go through an annual audit similar to a bank. They make sure that we have everything in place, from disaster recovery plans to appropriate IT. They also audit our files to make sure that we're doing what we're supposed to be doing for our clients. So they review some of the decisions we make. It's about 3 weeks, and it's not pleasant, as Justin in the back there can attest to. But yeah, it's really an invasive process, but it's to protect the consumer. And it is because there is so much fraud with the trust in the state. There is a lot of theft and taking. And, oftentimes what we run into is the first thing we do when we find out is we go change the locks on the house. And I would say half the time we show up, the children are already there dividing everything up, even though they're not supposed to be. In fact, funny story, we had a brilliant young guy that worked for us. First week, I sent him out to change the locks, and there's 7 children in the house pulling apart everything. He walks in, they go, I know they have money hidden in here somewhere. And they're literally taking the wall sockets out, looking for a fake wall socket. And he calls me up and he goes, what do I do? I go, you have to call the police. He goes, they just said they were going to call the police on me. But I said, just call the police and meet him there. This was his first week. He ended up staying with us for a really long time, but it was an interesting first week for him.
Most definitely. So Lou, could you give the audience one piece of advice about how to go about selecting the right professionals for estate planning, trust administration services? If we don't have someone, how do we go about finding someone we can have confidence in?
Yeah, I think empathy is important in selecting your professional, somebody that can understand your particular situation. We pride ourselves on hiring people who have empathy, that this is really about being of service to others. At the end of the day, some people get it from, doing good works for their church. Some people get it from doing local community stuff like soup kitchen, whatever. We hire people who enjoy helping others, helping families through difficult times. Because it's really it generally is one of the top 3 most traumatic moments in somebody's life, right? The death of the loved one, at least you hope, when you're gone, that it's a traumatic moment for them. But and attorneys just need somebody competent, somebody who understands, somebody who doesn't do, I think, trust and wills on the side, or a program on the internet. I mean, those are a disaster, in my opinion, oftentimes, because they're making you be the attorney. And unless you went to law school, I don't think you know what you're putting in there and what it's spitting out. So garbage in, garbage out is basically. So knowledge and empathy, I think, are the 2 most important things.
Thank you, Rich.
I did some thought on this after we had that conversation. I think the most important thing is somebody who doesn't start telling you the answers before he understands your questions. You know, there's a lot of estate planning law firms out there that, you know, you fill out a little sheet at the beginning and it's got, I've got 2 kids, 2 stepkids, and have this much money. And you walk in and say, okay, this is what we're giving you. If that happens, you should go the other way. Same with trust companies. You go to banks, trust companies, they will tell you the problem to your solution. And then tell you they're the only ones that have it. You want somebody who actually listens to your questions and knows what matters, and then starts trying to give you advice.
Right, perfect. Thank you. So, our mic runners. Madison, can you introduce yourself, please?
Good morning. Hi, I'm Madison Crafts. I'm with the Janelle Group, and we help our clients downsize and provide move management services.
Great. Thank you, Madison. Madison's going to take the right-hand side of the room. If you have a question, raise your hand, and Madison will come to you. And on the left-hand side, Melissa, can you introduce yourself?
Melissa Hartman, work for Schultz Law Group and Richard Schultz. No further introduction needed.
And are we going to see you next Thursday at the workshop, Melissa?
Yes, I will be there as well.
Melissa's going to take the left-hand side, so if you have a question, raise your hand. Melissa will come to you. So let's start over here. Yes.
I wish I knew the term that I just heard a month ago. Is there a new form that if you pass away and your trustee, say is your daughter, that they're supposed to turn into you, it's something upon death? Is there a new thing that we need to go ask our trust preparers about?
Great question.
There is a document, if you own real property, that you need to file. It's called an affidavit of surviving trustee or affidavit of trustee. And it's basically a deed that says, you know, I was the trustee, or, you know, my mom was the trustee. My mom's now passed away under the trust. My daughter is now the trustee.
Thank you. On this side.
Yeah, I'm not sure if I know the way to ask this question, but I was worried about that California issue. And whether a power of attorney or is a successor trustee, are they both affected by that law?
So on the power of attorney, I think that's an open question as to whether it would subject you to California income tax. Having dealt with this issue, I've seen that they've taken the position that it doesn't necessarily, but for the trustee, certainly it does. You know, there is no exception under California law. If you're a California trustee, it is subject to California tax wherever the assets are.
If they decline to be the trustee and then it goes back to a trust company, would that avoid that?
Yes, unless the trust company is in California.
Lots of exceptions. Yeah. Thank you. That was a really good question. Over here.
Hi, my question is similar. So for California, beneficiary or trustee, what's the cost-benefit analysis for the size of an estate that would kind of break even at that point? If all the beneficiaries reside in California, and if there's a trust executing the trust, can that be bypassed? The beneficiaries be bypassed of California income tax?
Yeah, so there's actually some creative ways to get around that. One of them is if you make the beneficiaries full discretionary beneficiaries. That means the trustee is the person who decides whether or not they get a distribution. So you don't say they're entitled to the income or they're entitled to this right away. If it's at the trustee's discretion, then that can avoid California tax unless they actually take money. And if they take money, then it is going to be subject to California income tax, the income portion. So trustee, there really is no way around. If the trustee is in California, then it's going to be subject to California income tax. There's really no way around that.
Including the beneficiary, if they take,
Yeah.
receive.
Yeah, so it's a 3-pronged test: location of the property, if the beneficiary has some rights to take income or actually does take it, and then the third one is domicile of the trustee. So,
Thank you. Sounds like your kids need to move to here.
well, I will tell you that there are people who follow that strategy, which is they move, and once you're out of the state for 12 months, you take a distribution, don't go back for 12 months. After the distribution, then the franchise tax board is somewhat stymied there. But, I mean, that does happen, where you have large accumulated gains and trusts, and people will move to Nevada. And although I have some friends of mine, and they had a very similar situation. They moved to Las Vegas, and the wife said, after living there for a couple of years, said, I really don't care about the tax issue. If you want to get divorced and you want to stay here, that's fine. I'm going back to San Diego, where the weather is awesome all the time. So she didn't care.
Thank you. Over this side.
Roger Kirkham, a couple of questions for Rich and then Lou, but
Actually, sorry to interrupt. Can we just have one question? I see there's lots of hands and lots of questions. So just choose your best one question for one of the panelists, if you wouldn't mind.
now I have to think.
Yeah.
Rich, after you go through the estate planning, do you recommend some of the family members having a closing meeting so they know who you are? So 5 years later, when you drop dead, all the kids are aware that this attorney represents so-and-so.
It depends. I love being a lawyer.
And Rich, you got 30 seconds. So we get through all
Yeah,
those
so
questions.
the answer is yes. The closer you are to falling off the chair, so to speak, the more important it is to have the kids involved and let them know who's who and what's happening. The more complex your estate plan, it's nice for them to meet the lawyer too, so they know what they're administering and we can clearly articulate the different roles. That's what I would.
Thank you.
I'm confused about the relationship between a revocable trust and a will.
Rich, Lou, who wants to take that?
That's a legal question.
At some level, they do the same thing, right? If you look at them, it says who gets what when you die. It's the way they get what you have to the people you want to get it to that differs. So a will run you through the probate system, which in Washoe County is going to be about 14 months. It's going to be between 3 and 4% of the gross estate. That means what you own before debts in fees and costs. So you have $1 million estate, you go $600,000. Your kids will get $400,000. The lawyer's fees are based on the million. So that's a bad thing. Trust does it all privately without court involvement, and if the circumstances are right, it can be done very, very quickly. And very quickly equals less money.
Thank you. Which side do we get to? Do you want to add something?
Yeah, I just wanted to say quickly that Rich and I are going to be here. So if we don't get to everybody, Rich and I are going to stick around for a while afterwards. So you're more than welcome to come up and ask questions then.
Thank you, Lou. And again, you'll have the opportunity at the workshop next week with Rich to more questions as well. Awesome.
Yes, I'm rather concerned about the trust perhaps not holding up if you have one created here in Nevada and you decide to move to another state. Not exactly sure. I was thinking of Hawaii, but that doesn't sound like a good deal. Could you rent an inexpensive room in Reno and claim that as your residence? It happened with an airline captain we knew. He lived in Los Altos. His wife was not going to move to Nevada, so he rented a place here. He'd come up about once a month, visit a few friends, and go back. And that was his residence in Nevada. What do you think of that situation?
So I will tell you that the residency issue is, I think, really important and can be quite controversial. I think it's like all things, it's really, unless there's a reason for somebody to question it, like an audit that probes pretty deeply, I don't see how they would know, but it happens. I mean, there's ways that, it's your driver's license. Funny story, I had a client one time, loved gambling, and he was a casino host, and he figured out the algorithms that if you're from California, the Nevada casinos gave you way more comps. So he goes, this is easy, I'll just get a driver's license using my friend's address in California. He didn't think that every time he hit a jackpot, the casino sent it to the state of California with his California address. And the next thing you knew, he was getting letters from the franchise tax board thinking he owed hundreds of thousands of dollars in tax and penalties. So residency is one of those things where unless there's a reason that you get caught or there's a reason to question your residency, I think you probably put whatever you want. So it's got to be your driver's license, mostly.
You have to have a driver's license. The state removed.
So I'll just stop because no one else can hear. So yeah, if you want to come up and ask more about it, yeah, please do it. Yeah, it'd be great. Back over here.
Yeah, my question is, do I need both of you? Do I need one of you? Do I need one of you to draft it, one of you to monitor it or execute it? What's the deal?
I can take the first part of that. Beneficiary, Brett Janelle, and let me spell it out. These guys are
So we do not practice law. We don't do any drafting at all. That's all attorneys. We just do the administration part, if you need us. Some situations you may not, but I would argue that anybody with more than one child generally probably needs a professional trustee. Thank you.
Thank you guys for coming today. My name is Kelly Higgins. My question is, what are all the documents that we need? I know it's probably case by case, but in general, if you have a trust, do you still need a will? Power of attorneys? Are there any other documents that we should be concerned about?
Yes, I'll take that one. If you have a trust-based plan, you still need a will. And what the will effectively says is look at my trust to make sure who gets what. So it just ensures that your will is honored, even if somebody tries to say it should be otherwise. Always need powers of attorney. Anybody that says the trust is enough on its own to avoid guardianship is either smoking something funny or blowing smoke at you. So you need a general power of attorney. You need a healthcare power of attorney. Those are sort of the core documents. I mean, there'd be some supporting stuff, certificate of trust, maybe an affidavit of trustee, memorial instructions, what to do with your body when you're done with it, those kind of things.
And I would just say that the will, just for ease on that, is generally a pour-over will, and it basically just says anything that's not in my trust, I meant to put in my trust, so please just pour it into my trust. And it does require the probate court's approval, but it is a simple filing that the probate court just rubber stamps as a general rule.
In Nevada, it's very simple. If you have property in another state that's not in your trust, it's not that simple.
Good point.
I have the microphone here.
Oh.
How are the fees for the trust company, should I choose to use a professional, structured? And are they pre or at debt?
So the way that we charge generally, it's generally between 1.5–2% of the net value of the estate and all those fees are collected at the very end of the administration. If it's an ongoing administration, you have a special needs child, or maybe your children aren't ready for the money and you want to wait till they attain a certain age, or maybe you think they're never going to be ready for the money and you want to make sure that they're going to be productive members of society and that this is really for a very specific purpose, then that fee schedule varies based upon value and, length of time that we would be serving. So it's basically a tiered system.
And percentage.
Yeah, it's a basis point system, but similar to any financial services.
Thank you. Where do we get to? Up the back there, Melissa. Thank you.
Hi, I have a neighbor who has her home in an irrevocable trust, as you know, since you made it an irrevocable one. She'd like to get a home equity line of credit that requires it coming out of the irrevocable trust. So can you talk a little bit? I'd like to help her understand the difference between the two and help allay her fears of taking out an irrevocable, putting it in a revocable trust to do that.
That's actually very complicated. So because you don't know why it's in the irrevocable trust. She may have chosen to do that for asset protection purposes, something like that, in which case you don't want to touch that trust. What I will say is I'm aware of 2 banks that will loan money to an irrevocable trust. And so if you ever call me, I can put her in touch with those banks. They are not local, but that's probably the easiest one. So just a real quick I'll save that, but if you come to the workshop, I'll talk more about that issue.
Perfect. Thanks, Rich.
Where do I keep all these papers that I have in my trust?
Document storage, we talked a little bit about that.
Yeah, and I think your attorney, if your attorney's in a different state, maybe your attorney's retired, I would engage a local attorney maybe, or a very trusted friend maybe. That's always or maybe your financial advisor. Somebody that, I think you choose somebody that if they did something that they shouldn't with those documents, would lose their livelihood as to where you want to store those generally.
Where are we, Melissa? Any questions on this side? Show of hands. There's a couple. And over. Yes.
I just have a question about the executor of the estate. Do they get financial remuneration for this? Excuse me.
Great question. So both for a will or a trust, is there compensation to the person who's the executor or trustee?
Yeah, generally it follows, Nevada law governs how much trustee or executors can charge in an estate administration, governs how much attorneys can charge. Trusts are totally separate. That varies. We generally follow state statute for that, unless there's some extraordinary items. So whether it's, I've been involved in estates where we had to charge special fees because there was a lot of real estate, 5 children, none of them knew each other, none of them knew that they had really, and there was a lot of litigation. There was a 41-year-old exotic dancer in the middle of everything. So there was COVID, blew apart the real estate sales, so there was some special circumstances, but generally, it's roughly about 2% is what we charge.
And what about in the case of I have my child or my brother, or are they going to get compensation? Is that optional? Do I decide?
The document can make that decision.
The document will usually spell it out, but what I tell people, slavery is illegal. Slavery is illegal. So if somebody's doing work for you, they're going to get paid. And quite often, if it's a trust, it's the same state statute that I incorporate by reference into the documents, unless you want otherwise. And then if they're an executor under will, it's by statute, percentage of the estate.
Yes, right.
Our trust was originally created in the state of California, but we've had it amended here in Nevada. We own property in North Carolina, California, and here. Our executor, our son, is in North Carolina. one of the beneficiaries, who's our niece, is going to get property in California. What happens to her?
So, I mean, she would receive the property. What would happen with the trust or estate is that, you know, we're talking about income tax for the most part. So there's going to be an income, if there's any income from that trust or estate, it will end up being partially taxed by California, a ratio, as it were. Now, North Carolina, I'm not as familiar with what's going to happen there, since he's the trustee in North Carolina. If they have similar rules to California, then it would subject to income tax the trust, but I don't know that they do. It's on a state-by-state basis.
But she wouldn't be taxed when she got the property. If the property was just deeded to her, there probably would be no tax to her.
Correct.
Not income. Great.
Yeah, it's only on income.
What is this deed after death?
Sorry, where are we?
Down here.
Oh. I think we're on this side, correct? And then we'll come back to you.
You mentioned that there's a problem with having property in an estate. I'm looking at getting a wintertime condo in Phoenix. My nephew lives there, and we talked about this. He agreed to be co-owner. Is that still a problem if they're an estate, you get some other property in with somebody? Should that be addressed in a trust or a will, or?
The benefit of naming him as a co-owner, I'm assuming it's in something called joint tenancy with rights of survivorship, is that if you stopped breathing, he would own the property. And if that's what you want to have happen, that could be a very efficient way to do that. If you want that property to go somewhere else, you'd have to change that.
Thank you. Yes.
A deed after death? What is deed after death? It's listed here on the back.
Deed upon death?
Yeah, it's a deed upon death or a transfer on death deed. Might have heard of a labor deed, something like that, if they're all the same. It's a deed where so when you do a joint tenancy, like what happens over, she asked about, when you put somebody on as a joint tenant, they own the property with you. So if you went to sell it, you need their permission. A deed upon death, you own it, but on your death, it goes to the person that you name. Now, the downside of it is with joint tenancy, it happens automatically. With a deed upon death, they have hoops they need to jump through it by statute before they can sell it or before they can take title.
Yeah, and I would just say that I see this quite frequently where people will just put their children's name randomly on their house or whatever. Just be aware that technically that's a gift under the tax code, number one, and for the value of the property. And number two, if you have a falling out with that child and they own half the house, guess what? That's a problem.
Or they get sued?
Yeah, or they get sued. That asset is not going to be protected from creditors.
Or go through a divorce.
Yes. So trust is a much better vehicle than just adding your children to the deed.
We had another question. I think we're time for maybe two more questions. One here. I see a hand over here somewhere.
Since this is so complicated, I've decided not to die.
We wish you well.
It's funny you say that because I had a client walk out of my office a couple months ago and they said, man, this dying stuff sure is a pain in the rear.
They sure will. Any last questions? So while I'm getting a mic run right now, I want to say one thing. I just really want to appreciate you all for being here, for taking the time to educate yourselves on what is a challenging topic. Secondly, I'd like to really thank the education partners who show up here every month, who help us set everything up, get the room ready for you, pack everything up at the end and so forth, all the time and energy they put into it. And then thirdly, actually I've got two more thank yous. I just want to thank my team, Alexa, Kim, Madison, Yvonne, Annette, all the hours they put into making this happen and making me look good up here. And then I'd just like to thank our panelists. These guys are super busy. have a lot of commitments, and I just so appreciate them being here and sharing their time, knowledge, and expertise so we can all do better. So let's
I did want to mention we were the pen sponsor today, and these are new pens. So if you don't like them, Emily is in the back. She's the one that ordered the pens. Let her know.
Thank you. So we have one more question over here.
I have a son in California who's remarried. His 2 children live in 2 different states. So in order for him to leave anything for his children, he has to put it in a trust. Is that correct?
No, I mean, he can still leave it to whoever. It's just really, gets into the nuances of whether or not there would be income tax associated with the production income of those assets.
And also, without a trust, it would likely go to probate in California before it gets to the kids.
Which is really backed up.
Yeah, depending on which county, that could be 2-3 years before it even gets started.
And meanwhile, property tax has to be paid, mortgages, maintenance, on and on and on.
That's what he said.
And just a quick funny story about assets in other places. I once had to get access to a numbered Swiss bank account and a safety deposit box in Switzerland. And that required, I couldn't believe how difficult that was. I had to get the signature of 3 judges, and then I had to jump through all these other hoops. And then I had to FedEx the whole package to the bank in Switzerland, only to have them open the safety deposit box and tell me it was empty. Wow. This guy went through a very vicious divorce, and he didn't take his wife off the safety deposit box. And he was attempting to hide assets from her. And so she said, okay. And she just flew over to Switzerland and emptied about $3 million out of the box. And so so then I had to have everything translated from Swiss German, all the apology letters from the bank executives to this guy explaining that it was really not their fault since he didn't take her off the safety deposit box. It was quite a fascinating case.
You have some of the best stories, Luke. I love the stories. I think we'll end it there. Can I just ask you all to complete your yellow evaluation forms and just return them to our team or leave them on the table. Be sure to check the boxes if you wish to attend the upcoming events. And then just lastly, to help my team, it really helps us if you do register so we know how many printouts to have, how to have the room set up, whether it's a workshop or an evaluation. So if you're bringing a guest or you're coming, if you just let us know, that really helps everybody. So thank you so much for being here. Thank you guys again. And they're going to hang around if you have questions.